Boa noite a todos e todas. É um prazer recebê-los aqui na FGV para esse evento. I'll shift to English, the language of this event, so that we can speak to our guest here. And first of all, on behalf of the Research Group on Competition, Public Policy, Innovation and Technology, Comppit, I would like to welcome you all to FGV. I'm Caio Mairo da Silva Pereira Neto, a professor here at the law school. It's a pleasure to organize this event together with Ibrac, the Antitrust Bar Association in Brazil, and the Global Policy Institute from Queen Mary University. Before introducing the participants, I would like to give the floor to Ricardo Mota, who coordinates the Committee on Digital Markets at Ibrac. Ricardo, the floor is yours.
Thank you, Caio. First of all, and on behalf of Ibrac, I would like to welcome everyone here. This is a very important event where we're going to discuss DMA and some repercussions in Europe, and likely we're going to discuss about Brazil as well. So on this regard, I'm really glad to receive this invitation from Caio, a professor at FGV, and also FGV as a whole, the partnership with Ibrac in many different fronts. So thank you very much, Caio. And thank you everybody for being here, and we invite you all to participate in this very instigating debate. So before just going back to Caio and starting the moderation of the panel, I would like just to let you know that Ibrac has different fronts of discussions related to digital markets. I'm coordinating the group at Ibrac, and we have regular meetings every month. We have very interesting papers that we are promoting, discussing. We have events that we promote. We host an event at USP in the beginning of this month with one of the commissioners at CADE to discuss digital markets, to discuss his book. And we are being very careful in the debates regarding the regulations in Brazil, especially bill of laws that are under discussion in the Congress. So these are some of the matters that we are discussing at Ibrac, and we would like to invite you all to come on with us and discuss inside the Ibrac. So everybody that would like to participate, that like to receive an invitation, please just reach out to Professor Caio or reach out to me directly, Silvia and the others. We're going to be glad to have you there. So without further latency, I would like to go back to Caio. Please, Caio, go ahead and let's start this instant panel.
Thank you very much, Ricardo. I think it's fair to say that Ibrac is probably the most important think tank on antitrust and competition law in Brazil, and produces a lot of interesting papers and reflection. And I think, especially in digital markets, is being a leading group in this discussion. And thank you very much for the partnership with FGV, by the way. And like just to register as well that we have here Leonor Cordovil and Tony, Raissa, and people from Comppit that are participating as well, who's a professor. Leonor is a professor here at the school as well. So we're here this evening to discuss the Digital Markets Act, the DMA, under implementation in Europe. Digital markets are certainly calling attention all over the world, and including in Brazil, but Europe is certainly leading a lot of the discussions. And difficulties in enforcement and some perception of type 2 errors or false negatives in recent years have resulted in a political push for ex-ante regulatory powers, where there is no need to prove a specific infringement in order to intervene in some of these markets. In this regard, DMA is probably the most important regulatory initiative regarding digital markets underway worldwide. It's the first large-scale attempt to deal with big tech using ex-ante regulatory tools and attributing wide powers to the European Commission on this matter. As any major initiative, it's also very polemic. So some argue that it's well overdue and maybe even too little, too late. Others argue that it's way too much and may lead to type 1 errors with overbroad interventions that may reduce innovation and distort competition in important markets. So we're here today to go deeper in this discussion, trying to understand how this new regulation will work, what are the challenges, and what are the potential pitfalls as well. With this very brief introduction, I'm happy to present our speaker and two commentators for the evening. And I'll start with our speaker, our guest, Professor Ioannis Kokkoris. Professor Kokkoris holds a chair in competition law and economics at the Center of Commercial Law Studies at Queen Mary University of London in the UK. He's also the Dean for International Affairs for the Faculty of Humanities and Social Sciences and the Director General for Queen Mary Paris. And now I just learned that he's also taking the deanship at the law school at Queen Mary. So congratulations on this. Professor Kokkoris is an expert in competition law and economics, has published widely. His main research interests span in all areas of competition law and policy, including comparative competition law and economics, and policy focusing on the EU, the US, BRICS, and Asia. I had the pleasure to get to know Ioannis during my visit at King's College, and it's an honor now to welcome you at our school here at FGV. As our commentators, I have the pleasure to introduce two great friends from a long time who are leading figures in the competition law field in Brazil. Silvia Fagá de Almeida is an economist, director at LCA Consulting, LCA Consulting, one of the top consulting firms in Brazil, dealing with applied economics to antitrust and regulation. And she holds a PhD in economics at FGV and also teaches here. And Cristianne Zarzur, who is an attorney and one of the partners leading the competition practice at Pinheiro Neto Advogados and one of the leading figures in the Bar Association in Brazil. So, without further ado, I'd like to give the floor to Ioannis, and so that I can start our presentation. Ioannis, thank you.
And thanks, Caio. Thanks, FGV. Thanks, Ibrac, for the invitation. It's a great pleasure to be here. I assume this is on, so I can just talk. Yes, that's on. I have a few slides which help when someone is jet lagged to follow some type of line of thought. But I also want to share some reflections as I will be going through, because I've been following DMA for the last few years now. I started following a Commission's approach on Google, on the Google search case, going back all the way to 2011-12. And I have a genuine interest, as we all do, in this area. And I have an interest for two different reasons. One is the substantively analytical one. I'm an ex-enforcer, so in my blood, I still feel I have some enforcer's DNA there, so I still want to do the right thing, and I still want to make sure nobody's harmed in the wider community. So I follow the DMA to see whether I think this does what it's saying to do. Secondly, the concern that I have with this type of huge changes in the regime, in any regime, when we are looking into US, when we're looking into EU, if we look into Australia, ACCC, some of these regimes are models for many other competition authorities and regimes globally. So when the DMA started being discussed, when actually it was even before we had the first draft, I was in a
Just get the microphone.
Oh, yeah.
Well.
Sorry. I was in a Central Asian country. And we were there to discuss a reform of their law. It was a young competition authority, a new law. Just to give you an example of how new the law was, the fines for cartels was based on minimum wage of the country, of the national minimum wage. So, for example, a fine of the cartel would be, let's say, 200 times the minimum wage. So it was a country that we really wanted to change the regime. When we were talking with the authority, though, the senior management was also very exciting about digital markets, and they wanted to have their own DMA at a time that we didn't even have a draft text by Brussels on what DMA would look like. And the concern that at least I shared with them is that you really need to learn to walk before you start to want to buy a Lamborghini and start running around. But the problem is when you have EU, Commission, US authorities, other major regimes coming out with these types of acts, they are a model for junior competition authorities, and the big authorities have the resources, have probably are able to enlist expertise. The younger do not. So there is there's a huge chance that you will have really inadvertent consequences in many countries because of a regulation you decide to pass. That's not a criticism on DMA. This is the broader implications of a changing landscape when we have something like this coming out. And this is not something the Commission can do or US authorities can do to take into account when they will be trying to address their own problems. But this is the collateral damage possible collateral damage that I fear may happen in certain countries globally. So setting a context. When DMA started being rumored, as you may realize, there was a lot of uproar by different stakeholders for different reasons and different perspectives. Understandably, it's something totally new, which is aimed to actually change the landscape on digital. If we go through a bit in the detail of the DMA, and I will do it in the next few slides, not all is new. I mean, yeah, it is a new regulation, it is ex ante, yes, but we're not talking about the Commission coming out with a list of new conducts, new areas that it will enforce now competition law, where before it could not. Depending on how you count, because the Act has changed so many times, the articles and sub-articles and sub-paragraphs of sub-articles, depending how you count it, probably 50 or 60%, I would say 60%, is already existing case law. And not existing case law 5 years ago, existing case law 20 years ago. So it's not something new. So I think there was a lot of reaction, which was probably overreaction, to be honest. So that's one reflection. Second reflection, I haven't followed many EU regulations. I have followed a few. I think this is the only one I can remember in the competition area that the Parliament adopted from day one a harsher approach than the Commission, in my view. So if you compare the drive behind Parliament, specific MEPs, but Parliament in general, for this Act, it was something which for me was really surprising. Secondly, if you compare the final, or it's not final, the finalized, let's say, Commission text and how this changed after Parliament, you had areas of practice, you had conducts which Parliament took away from a more lenient type approach on these contacts and move them into the more hardcore type approach on these contacts. So we have a regulation where there is a strong, I don't know if it's a political will, I would say there's a strong sense in Europe that we really need to do something about it. And that was really reflected in the Parliament's comments. I think the Commission did the right thing. Commission is not there to appease the Parliament or appease what may be hot this year and next year and then may change in 5 years from now. Commission is there to do its job. So Commission was actually pushing back, in my view, and rightly so, on a number of these conducts. But it is eye-opening how far the Parliament went to actually push through this type of conducts and adopt a harsher approach in the regulation. As you see, I'm not even following the line here, I'm just reflecting. Another consideration I see, Commission is not a regulator. Sorry, let me rephrase this. DG Comp is not a regulator. And DG Comp has to actually enforce this. Regulation economics and competition economics, they're similar. They deal with the same type of broader issues, but they're not the same. I'm a competition economist. I cannot do regulation economics. So if I am asked to adopt a regulatory frame of mind in enforcing this, how will I be able to do so? I may be able to, but the bottom line is Commission needs to get staff. DG Comp needs to get the proper resources with the proper frame of mind to do this. Because that's not ex post enforcement, that's ex ante. What the amazing economists in DG Comp know how to do is ex post. Some of them may know how to do ex ante as well. But there needs to be some proper resourcing to DigiCom for this, and to all other authorities which decide to go down that route. Next point, I was looking at the US Act, the US bill, I'm sorry, the bipartisan bill, which is going to, it's supposed at some point to go to the Senate. I understand that it was expected to go before the summer recess. It hasn't. Summer recess is over on the 8th of September. Depending on who you ask in US, advocates are saying, don't worry, this is going to go through between 8th of September and midterm elections. If you ask proponents, they will say, there's no way this will go through before midterm elections. And it hasn't gone through until now because there was no appetite in the Senate for this to pass. But outside the politics, I was looking at the two bills, at the bill and DMA. I think the US is clearer, is narrower, much narrower, so that's a drawback there possibly to be discussed. But I was reading the US bill and I understand what it says in English. I was reading this bill, some of the articles there. I'm not native English speaker, as you have realized, but I've been in UK for many years. I think I can read and understand. I'm reading some of these some paragraphs, and it feels like an IQ test. You need to go through, you start with this first word there, this connects to the third word over there, and this whole paragraph, you need to read it twice to make sure it makes sense. Data, the paragraphs on data, for example, some of the interoperability aspects. And that is a problem. How are you going to enforce it to start with? How are you going to defend your clients if you're looking at something which is so convoluted? And I understand, I'm taking both sides here. It's not easy for a legislator to try and predict what can be the problem that will arise, because that's what this law is trying to do, and it should do that. What can be the problem that will arise that I need to preempt with this law? It's not easy. But I think the US, it is narrower, which helps being more succinct and clearer, but the way it's drafted, I think it's easier to understand. It may never become law, we'll see. We'll be here to actually discuss that if necessary. But I think the US has done that a bit better in that respect, albeit narrower in areas that it actually touches on. Nothing else to go on here. I'm going to move into more the DMA here. I just wanted to set the broad picture. So unfair, it addresses, most of you will be fully aware of this, unfair practice by gatekeepers that fall outside the EU competition rules. There was a huge criticism in Europe that Commission is taking ages to deal with big cases. Microsoft, 7 years, I think. 1998, 2004, 6 years. Google, I think, complaint was 2010, if I'm not mistaken, on search. Decision was 2016, 6 years, 7 years. I think Google may be slightly longer. And the problem was not just the fact that it takes time, is that by the time you reach a remedy, the problem either has dissipated or the remedy will not work. So if we take Microsoft, the Microsoft case, the problem with Explorer was the pre-installing Explorer was foreclosure theory of harm. So Commission came up with a very clever actual idea at the time, and I think it's still something that the authorities will use. The choice screen. So if you ever bought a laptop in Europe or a PC in Europe after Microsoft, when I was when I was setting up the PC, I would get a choice screen for what Explorer I also wanted to download. Problem seemed to be, though, by the time this happened, Explorer was losing market share anyway, and the remedy did not change anything. So you have a remedy there which may not work. And that's not just in the big tech sector. If you consider utility regulation, utility cases, you have many types of remedies in utility cases, which competition remedies, which do not really work because of the consumer behavior. So it takes long, and the remedies may not work. So that's why that was, I think, the main driving force behind having an act like DMA. And I think the Commission tested the waters with Google search, Google shopping. I call Google search Google shopping. With Google shopping. Novel theory of harm, new theory of harm, a lot of controversy as well. Tested the waters, this went through, so then Commission felt empowered. We need to come out with this now. And the earlier, the proposals for what that would look like, I'm taking you back now 4 years ago, 3.5 years ago, the different proposals on the table included aspects which would be worse than what we have, which goes back to the point I made in the beginning. Commission has taken a very mature stance on how it wants to regulate big tech. It could have gone much more interventionist. It was pushed, in my view, by the broader environment, the broader sentiment, to go much harsher. It decided to hold its ground and actually be mature about it. And I think what we have, with drawbacks, is an outcome of the Commission trying to have a cool head in deciding how far it will go on this. If we focus a bit more on the DMA covers the core platform services. We start now with translation issues. I was saying earlier, online intermediation services, search engine, social networking, operating systems, cloud, advertising, etc. So covers all the services you can think of that the big tech is actually involved in. This is indicative, what we know now, but this will cover additional services as they come on board. Because the wording is drafted in the way, if one of the big tech decides to come up with VR, a new VR service that I will not be here, I will be in London, you will be seeing me here virtually, that can also be part of the DMA. Why? Because it's an oligopolistic market. Because it's the same type of problems we have in any oligopolistic market. But here, because it's more difficult for the market to self-correct, but also these type of markets have a much wider audience, which means possibly more consumer harm. The Commission decided to focus it specifically, to address it specifically with the regulation just on the digital. I'm going through a bit quickly here because these are things which are known to most of us, and that's why I'm a bit rushing here. I had to put this in. I'm a European after all. I'm a true European. I had to put this in to go Commission, contestable fair digital market. So I had to add it there. You can read it. I'm not sure if DMA will achieve all of this, or any other regulation in any other country, but it's a good aim to have. A gatekeeper has received so much attention. How long is a piece of string? Is the numbers right? Is that the right turnover? Should we be looking at turnover? Should we be looking at users? How do we cut it? How do we define who is a gatekeeper? The US bill has followed a similar approach to the covered platform equivalent, with trying to determine users. There was a lot of discussion prior to DMA becoming law. Actually, it became law. And there was a lot of advocates who were trying to change the definition of this, try to change the criteria of this. I think and there was also a criticism that the Commission drafted this in order to single out certain companies from certain countries in your neighborhood, broader neighborhood, let's call it. I do not know if that's the reason why they drafted in the way they did. But I can definitely see why they feel that these companies have the capacity to actually create competition problems, so they drafted these rules in a way to actually focus on this type of companies, not Europeans, which by default are smaller anyway. So, in principle, the law will apply to a European company, if it ever becomes like the ones that we're talking about. The fact that it only focuses in practice on the big tech which are not European anyway, I don't think it is because the Commission was trying to be territorial, I think is the word, in this respect. But there was a lot of discussion whether they should the criteria should change because A, they were not accurate enough, they were not representative enough of reality. They were not representative of reality in the proponents' view of changing them. And secondly, because they felt that they were discriminatory, to use a better word. But nothing much came out of this fight. The obligations that gatekeepers have are listed in 2 articles, Articles 5, Article 6. I've read so many times these 2 articles. I can even tell them by heart now. Repeat them to you by heart. Article 5, in my view, is what we would call a hardcore list of contacts. So if you are within Article 5, good luck trying to actually come up with a defense to argue you should not be doing, you should be doing what you are supposed to stop doing. Article 6, I love the title of Article 6, which are contacts which are susceptible to further clarification. What kind of title of an article is that? I understand that the Commission there is trying to say, look, we cannot shoot everything because some of these contacts may have a very good reason for existing. And here you go, companies, come and tell me why these contacts should not fall within Article 6. So the way I see Article 6 is like an enlarged list of efficiency defenses, much larger than anything we've seen in any other regulation, any other law in competition. Because 1013, EUMR, mergers, efficiency defense is very small, very vague type of things. Here you have a whole list. Now the problem between the 2 articles is data is mentioned in Article 5, data contacts are mentioned in Article 6. Where is the line? Where does the line stop from an enforcement point of view? Because some poor person in DG.com will actually have to enforce this thing. So where will the lines, where will the boundary be? I'm not a technical expert. I hope technical experts will be able to give answers to this, because a lot of this is very technical, also the way it's worded. So I hope the Commission will have the assistance, the objective assistance, of technical experts to be able to guide them through how they can address some of these practices. On the data contacts that I mentioned, there was a lot of discussion how intrusive this is. Can big tech ever use data again of customers, of users? And Commission again there was pretty mature. Commission says that you can use data as long as you have GDPR approval, in effect. So yeah, if I give my consent, the company can still use my data. Goes back to the point I was making earlier, goes back to the consumer behavior. Will I give my consent? I'm not sure how many of us, when we receive this annoying window, give consent. How many of us have given up trying to say no? The point is, unless we say no, then this is useless. Not the whole thing, this particular paragraph. Could the Commission go and say no data usage, full stop? That would be probably a bit too much. I don't know. I'm just putting questions out there. So the Commission, I think, has been quite balanced in this. What I have tried to do here is I have tried to take Article 5 and link it to either past or ongoing cases. Why? Because in spite of the initial surprise of the legal business investment community, economic community, not everything is new here. So if we take, for example, not combine or cross-use personal data, you had a case. You have a case. You had a case and you have a case already. So even without that, the moment you have this decided, you have at least a strong, as an authority I mean, you have at least a strong tool in your weaponry. Allow business to offer better prices or conditions that are offered through the online intermediation. We have already Amazon case on this. Not to go to earlier cases on MFNs. So this type of conduct already exists. Why would the Commission feel inclined to come up with a regulation which will actually list them specifically than using precedents? Goes back to what I was mentioning earlier, 2 points. If you want to come up with a new enforcement priority of a new conduct that you have not seen before, self-preferencing, as a competition authority, you really need to do a lot of work to make sure that your new approach sits within the precedents and will not fall in court. So it takes a lot of time, takes a lot of effort. You have it in a regulation, it's done there. There's no need anymore to spend a lot of time. It's there, it's in the law, it's the new law now. But I understand why the Commission felt it needed to restate some of these more nuanced conducts which considered abusive because of its experience on the self-preferencing one. Allow business to promote, offers and conclude contracts with end users outside the platform. App Store, payment systems. Already ongoing case. And these are cases which started probably not at the same time as DMA, some of them, but not far off when the DMA started. The draft DMA, I mean, the whole discussion started in Europe. Provide advertisers with sufficient information about price paid by the advertiser and remuneration paid to the publisher. That's the ATTEC. Now DOJ has an ATTEC case here in the US. So this is the ATTEC case. UK has investigated this market too, the online market, the online advertisement market. Article 6, again, these are the ones which the companies have the possibility to explain, to provide the context within which they may still be allowed to continue with the conduct. Not to use data that is generated by the business users and it's not publicly available. Again, similar case, Amazon. Allow interoperability. That goes back to Microsoft and the servers. So it goes back to almost 20 years now, 18 years now. MFN again here, not to treat more favorably. You can do it as an MFN or you can do it as self-preferencing. So you have a case law there, and at least for this conduct has been supported by the courts. Yes, it took, with the court decisions, it took 12 years, let's say 10 years to be nice, but it's still, you have it there now. Apply fair, non-discriminatory general conditions of access. If we do not want to focus on the App Store, we can go to a number of cases which are about access, about discriminatory conditions on contractual agreements, under 101 or 102, under anti-competitive agreement law or abuse of dominance law. So there are cases there which could have allowed the Commission to use as precedents. But if each case takes 7 years, how many can you start? And you have only here we have probably, let's say, 7 conducts. How many years do you need to run 7 cases on these 7 conducts as an abuse case? Either you need to increase in size, or you need quite a lot of time, by which time this may not be relevant anymore. So that is the rationale of having the DMA. On mergers, inform the Commission of any intended concentration, irrespective of whether it's notifiable to the EU member state. Again, a very balanced approach here, because there was a lot of discussion that from the one far extreme in my view, gatekeepers should not be allowed to buy any startup at all, full stop, to all the way to the other end, let's do nothing about it. I think that's a very balanced view. Create some uncertainty because you notify the Commission. I do not know if the Commission will, if you can expect a response of the Commission saying you are clear. They cannot, I don't think they can say you are clear. Will they say that you will not need to notify? I really do not know that point. Maybe they will actually say you do not need to notify. So I guess at least you have some certainty that they will not come back haunting you at some point after the deal closes. This is exactly what the gatekeeper will have to do. DMA does not provide substantive assessment guidance, but we all understand that this will be the standard substantive rules we have in EUMR. Nothing will change there. So this first sentence is the criticism that I always hear outside Europe. How can you, Commission, be the prosecutor and the judge? I respect the concern, but it's not just Commission who actually is using that system. I think, I may stand corrected, but I think it's the minority of authorities, of jurisdictions which are using a litigation system. So I think this is the standard model that we have. And it's difficult as a competition official to always know better than the company when you are not the company. And when you can be, no matter how hard you try, and how many different views you will get, and how many data you will get and evidence from different parties, you always think, okay, what am I missing here? Am I missing something here that is not being shown to me, or I don't have the capacity to understand because we're talking about a very technical subject? So I feel more sorry for FTC and DOJ that they have to litigate as an enforcer, although I also understand the other aspect which says, okay, but at least they have to prove any far-fetched, crazy idea they wake up with. And you, Commission or whoever else, don't have to until you go to court, and then for 3 years from now, at least. So, but I don't think it's the wrong approach to follow, in my view. As an ex-enforcer, I don't think it's the wrong approach to follow this one. DMA, I say there, is expected to uniformly address. I should have probably written it is hoped that it will uniformly address issues from different settings. I still feel there is a big challenge ahead of the Commission, and I still think it will take probably 2 years to have some first sightings of how the Commission will deal with these issues. I know for a fact there are a number of law firms which are about to press send of a complaint based on DMA, both in UK and Brussels. But we will need to wait to see how the Commission approaches this, how it prioritizes them, what they prioritize, how they go about it. A list of prohibition obligations is rigid, might not address future developments. Okay, but that is, I put it there because it's a criticism, but I fully understand that you cannot always address future development. That's why the law is drafted in a way, the DMA is drafted in a way that it's a bit difficult at times because it's trying to predict what may happen and how we may be able to preempt it. But it will not cover every possible new issue in big tech. Quantitative criteria for gatekeeper, that was again the concern that might be misleading. it is a concern that has been raised. I have it there because it's a concern that has been raised. I do not know if that's a valid concern. I have it there because this took a lot of attention, this point there. And lack of a clear efficiency defense, because again, Article 6, if you have time at some point, read Article 6, just once. You don't need to read it anymore because it's bad for your health. Read it once. See what you understand out of it, the way it's written. So it's not, here are the criteria based on which we will accept an efficiency defense. This Article 6 is, here is what you could argue, these are the conducts that you need to come up with an argument why we should allow you to do that. 1013 EUMR has the criteria there. Article 6 does not have the criteria for assessment. Only says, for this type of conducts, we will be nice. Come and talk to us. And on that, obrigado.
Thank you. Thank you, Ioannis. This is a very interesting presentation. I think it brings a lot of food for thought. And I'd like to give the floor to Cristianne Zarzur for her comments and questions so that we can have some interaction here. And then afterwards, Silvia, and then can open for Q&A.
Thank you, Caio. Thank you, Ioannis. It's a pleasure to be here. Thank you, guys, to be here at this time. So I think that it's a consensus that there are a lot of things that we don't know, right, Ioannis, with respect to digital markets. So I made some notes here. And as you mentioned, with respect to DG Comp, CADE is not a regulator. So our antitrust authority is not a regulator. So regulation in Brazil is being made by regulatory agencies, always. Of course, we have some cases in digital markets that have been analyzed by CADE and are being analyzed by CADE. Many of those that you quoted there are also being investigated in Brazil. Until very recently, CADE was, by means of its chairman, Alexandre Cordeiro, sustained that there was no need to have specific regulations or a new regulation to implement or to bring new rules that would be specifically applicable to the review of cases in digital markets. But now, with all these moves in Europe, in the US and in other countries, China, Japan, Australia, of course that the antitrust authorities here are very concerned or became more concerned about being very far away from the point that other jurisdictions are. So we are listening now more strongly from CADE and CADE members that we need to move fast. And move fast here, it will be a little difficult because the challenges are very strong in any place, even in more mature jurisdictions as Europe and the United States. But here is where we are. So we are looking at these moves, and our impression is that Europe now will inspire CADE, as you said in the beginning, and other younger jurisdictions to implement rules to regulate digital markets. And the challenge is exactly what you have just mentioned. They are not regulators. The antitrust authorities are not regulators. So how can you implement these rules in countries as Brazil? How you can adapt rules that are that would address the reality of the local economy, looking into efficiency, innovation, and many other issues related to what this data-driven economy, e-economy, brings with it. So you have many positive aspects of the digital markets that are very positive for economies, nascent economies or younger economies as Brazil. So this will certainly be a challenge for us. Let me look in my notes here. And a decision to be taken here is who's going to do that. It will be the antitrust authorities. It will be the authority in charge of data protection. We have a new one here in Brazil. Maybe this could be a way to go, having parallel entities looking into the matter, because this is not only an antitrust discussion. It's clearly a discussion that involves many other aspects, like consumer law, privacy, innovation, IP. So we have several aspects, several issues involved in the discussion, and it's not only antitrust. And another discussion is what would be the best proxy? It's the consumer welfare, or this is not the main subject here anymore? How would we define the markets to see where is the market power? Is data? Is market power driven by data? Especially when you have this DNA loop, when you have data, network, and activity moving together. The more data you have stronger networks, and you have more activity generating more data. So you have the e-commerce, e-economy driven by this DNA loop. And we are not used to that. The authorities are not used to that, but this is a reality. So we have a lot of lessons to learn, and the authorities have a lot of lessons to learn. So we have a long way to go. And another thing is, do we need this legislation here, or the legislation that is being put in place in other jurisdictions will apply automatically to this big techs, because they are everywhere. They essentially operate in all the countries at the same time. So whenever you impose all these restrictions in Europe, and soon we'll have the restrictions in the US, would they apply automatically to these companies in Brazil? Because it will be a general rule of the companies, we cannot do that. So we cannot do that not only in Europe, we cannot do that anywhere. Or would these companies be able to implement practices in Brazil and in other countries that do not have the regulation, because here they will be more free to continue to do their businesses in the way they have ever done, because there is no law and there is no penalty. This is something that we need to know, because you have compliance policies on these companies that I would assume that they will be careful to implement practices that are prohibited in Europe, in Brazil, or elsewhere. So this is another discussion that we'll probably have to face. And the only thing that we know and is that our data is being used to determine what we are going to buy, and what we think now, and maybe what we will think, and maybe what we will want, because it's a huge power deriving from having all this data bank. So I think that we have a lot of challenges. You have challenges that are maybe more concrete, because Europe has already the legislation put in place, but the challenges are there for everyone. So I think that it's very good to have these discussions comparing the jurisdictions, even though they are in different degrees of maturity. But I think that Caio will be holding this type of discussions here at FGV and in other places very frequently from now on. Thank you.
Sure. Would you like to react to that?
Just two reflections, two comments. One, on should Brazil come up with a similar regulation? I think you are in an enviable position, not just Brazil, many other countries, that you have two major authorities, EU and US, US will see, coming up with this new law, which they will have to enforce. Mm-hmm. And they will make mistakes, as all authorities will make mistakes when they enforce a new law. So there will be a new equilibrium in a few years from now of how our competition enforcement regime will operate with DMA. So DMA will be something like EUMR was 30 years ago. So standard practice. Mm-hmm. And I think the Commission will have a lot to learn. And I think you will be better off if you, at that point, decide what are the best parts you want to keep or improve or get rid of. And you will come up, I think, with a better regime for you. Second, goes back to the point you were making. Will the big tech, if the big tech have to abide by in Europe, will they just say, okay, there's no point?
Certainly not. Certainly they will litigate.
Two examples I have there from past cases. If you were buying in 2008 a PC in US, you did not have the choice screen. So Windows produced a specific Windows software just for Europe. Google, when Google case was at the later stages, search, the shopping, Google shopping, at the later stages, I was talking to a client in the US, and we were at the same time, both of us, Google.com, both of us, and we were putting the same search term, both of us at the same time on the phone. I was getting a different result. Google started to change the way that the web page was looking than my client was getting in the US for the same search term on Google.com at the same time. I do not know if it's technically possible for a big tech to kind of segregate the market and say, well, we can technically deal with Brazil differently than with Europe. If they can, I think they will. But maybe they cannot. So then you have the collateral benefit of having another regulation safeguarding your interests.
Thank you. I fully agree with you.
I think that's a very interesting issue on whether other countries in younger jurisdictions need to actually, before jumping into the bandwagon, just like wait a little bit, right, and try to understand where this is going. I think that may be something wise to do, at least for a while. But let's listen to Silvia, please.
Okay, thank you. Can you hear? Okay. Thank you all for the invitation to join this interesting panel. Thank you, Ioannis, for such a great presentation, for sharing your thoughts with us. Well, I think we basically all agree now that an ex-ante regulation will be necessary to complement competition policy, especially because when you think about the issues related to digital markets, they are not related only with the competition environment. We also have market failures that we need to address, such as information asymmetry, externalities as well. Those are at least the traditional market failures that usually drive regulation. And this is, you can have this kind of problems in the digital market as well. So trying to address the harm that the consumer may be facing because of a negative externality with competition policy, which is trying to address the deadweight loss, which is another kind of harm that consumers may face, is probably not going to be effective. So you need to have different tools to do the right public policy in this sense. So I do think that some kind of regulation will be necessary to complement the competition policy. Otherwise, we may be trying to solve some kind of problems that are not going to be solved with this kind of instrument. And at the same time, I do know that maybe DMA is too focused on the problem of big techs being big. And this is another market failure. Natural monopoly is a market failure as well, but it's not the only one. So we need to bear in mind that probably some of the bad aspects that people are discussing about digital markets are not related to deadweight loss or the lack of competition or problems that competition will solve. So this is something that you should bear in mind. Otherwise, we'll be designing remedies or designing regulation or designing institutional framework that will not work. And this is something that I think the DMA probably is focused too much on the type of, the format of the companies and the size of the companies. And then it's addressing only one of the market failures, that is natural monopoly, not the other kind of failures as well. So this is something that is kind of concerning me when I try to understand the DMA rules. And another, so related to that, I do agree with Chris that's going to be, and with you, that's going to be very tough, very difficult to design the rules, ex-ante especially. And even the institutional framework, who is going to enforce this kind of rules. This is something very challenging, especially in Brazil, because I think that CADE is not prepared in the sense that the law and all the things that would have to change to include this kind of concerns, it's not in CADE's scope to deal with that. So I do understand why Alexandre Cordeiro says something like that. He's maybe changing his mind, but in the beginning, I understand that CADE is not going to do that because it's not its work to do. It's not its job. And then when you're designing the possible regulation, I do agree with you that maybe small companies is not going to be willing to grow. Otherwise, they are going to be subject to DMA. So this not be something that they're going to wish for. So maybe you're going to reduce competition in the sense that even those small platforms that could be contesting, challenging big platforms' market power, they're not be willing to do that. Otherwise, they're going to be in another kind of category in which they are going to be subject to DMA. Here in Brazil, we have a reference from our tax system that some small companies, they do not want to grow. Otherwise, they're going to pay another different rate of income tax, and they decide to stay small. So this is something that you should bear in mind. But also, once you try to reduce the scope of strategies that big companies can adopt, at the same time, you may be reducing or curbing the competition among them. So big techs could be competing among them, and they're not going to do that because now they are going to, okay, if I try to innovate in this sense or try to do, not really innovate, but doing some commercial strategy or try to do a incremental innovation, this may be subjected to DMA, and then it's going to be very complex. So let's stay accommodated here and not try to innovate or try to compete with other big techs or other big platforms. So this is another issue that I would like to hear your thoughts, everyone's thoughts about it as well. And about litigation, as you mentioned, it's not so easy to understand the writings and the rules. Here in Brazil, I would bet that we'll face something similar as well, and then we'll have a lot of litigation. I heard that the European Commission is already starting an office in the Silicon Valley, so they can have a closer relationship with the companies there, which I think is a very positive strategy. They are willing to negotiate and hear the companies and have a closer relationship with them, so I think it's very positive. But at the same time, it's a good time to be a lawyer in the US, right? So, and an economist, yeah. And so, and I think that sometimes those companies may have more resources to initiate a fight, even against the European Commission, and then you're losing the focus of the regulation. You're just starting a judicial fight, and it's not going to be good for anyone, you know. So those are my first thoughts about it, and let's hear the audience as well.
Thank you, Silvia. Would you like to quickly?
Just very, very quickly. On the litigation, I think Commission is in a very good position because across all the appeals in major cases, it has a very large win rate. That doesn't mean necessarily that it has amazing cases. It means the courts in Europe, General Court and ECN Court of Justice, is supportive, has been supportive of the Commission much more than the UK courts, for example, have been on CMA. So I think Commission feels more empowered by the way courts see enforcement in Europe compared to how empowered CMA feels. And on just one more point on the argument you were making on the startups, and you will reach a level, then you will fall to that, and then you were comparing with tax. That is a concern. What I would hope is that this group of firms will be small. The group of firms that will decide not to go, that would be able to reach that level, and will decide not to, because I would hope this is more. Otherwise, you can have a significant impact.
Yeah.
Collateral damage going on innovation in markets.
Yeah.
Thank you.
Thank you, Ioannis. Just one correction, Silvia. I think being a lawyer in the U.S. it's always a good time to be a lawyer in the U.S., right? I mean, you litigate everything, so it's kind of. But let's open for Q&A from the audience. So anybody would like to make a question and to open for discussions? Oh, just a second. Here, we have one here.
I thought that you would ask a question. So, first, thank you very much, Caio, for bringing a professor here. It was a wonderful presentation, and thank you very much for the opportunity for us to have you here, and also for Silvia and Cristianne and Ricardo, my partner, for the debate. So my question was more related to what Silvia has just mentioned regarding not litigation itself, but I heard, we've read a lot of criticism, obviously from lawyers and from papers, and what I saw is, I don't know if it's true, but that the DMA, as it is, opened less doors for possible negotiations from the companies with the Commission than comparing to the framework that we have now. So if we compare how it is, like a proceeding, the companies have more space now to negotiate and try to find a solution than what they will have in the future. So I would like to hear from you if you agree or not. Thank you.
That's an interesting view, because the way I read the conduct under Article 6, it's the way I read the title of Article 6 is the Commission inviting comments to come up with, come and discuss why you should still be doing what you're doing, why you should still be using data from different services, for example, and persuade me that it makes sense. I think, in my view, Article 6 opens up quite a lot of, gives quite a lot of room to big tech to go and discuss. And the Commission, in my view, shows it has an open mind to understand. Now, what the Parliament did, took some of Article 6 into Article 5, but that's not the Commission's doing, that's the Parliament's doing. Mm-hmm. But we still have, though, an Article 6 there with some conducts which the Commission says, come and talk to me. What I do not know, I think a technical expert will be able to tell us more about it, is whether what is left in Article 6 is actually of any value. Because if what is left in Article 6 are conducts which are anyway not something the companies would do, or not something they not do technically, or would not do from a profit point of view, then Article 6 is just there as a facade. And that I do not know, though, because I cannot assess whether what Article 6 says, these conducts are important or not for the companies.
Can I just add, in the same line of Leonor's question, do you think, because it sounds as if there is a presumption of violation, and because the burden of proof is on the company, so you made something wrong. You have to prove to me that I'm wrong, I'm the Commission. So do you think that this is it? I mean...
Can I add just one thing here? So this is exactly the road I took, and I would like to honestly ask you, Professor. You presented a very interesting idea of both articles, and I had the privilege of listening to some European professors in the last month trying to explain the DMA. And each one has his idea and reading, and because it's pretty new and you don't have precedent, so it's quite fair to have this divergence in the readings of the articles. And Article 5, my understanding from what you presented, we are switching from a rule of reason approach to a per se approach. Is that fair? And Article 6, we are switching from a burden of proof on the Commission to a burden of proof on the companies, on the big techs. Is that true? Is that fair, this reading? And just complementing one additional question. Especially on Article 5, it seems more reasonable for me, because one of the problems that DMA tries to address is we need to speed up investigations. One of the problems. We have others, but one of the problems were, one of the problems was Google Shopping took 7-8 years inside the Commission, almost 10 years, I think. So we need to speed up. How changing the burden of proof would speed up, would solve, or would contribute to solving this problem? So I think there are a lot of questions, so I'm going to stop here.
Can you repeat the last question again? How many years?
I think Google Shopping took
About 10 years.
About 10 years. So how do you think that this switching of approaches in the Article 6 and 5 would speed up investigations, would help to solve this problem?
The first comment I wanted to reflect on is you get 3 professors and you will get more than 3 different views on the same topic. So
it's like economists, you have 3 and you have 4 views.
No, academics, I think we can multiply more. We can multiply geometrically compared to economists.
Academic economics.
But on the substance, let me start with the latter one. How many years do I think it will take? I think it would be a huge failure if enforcement of DMA takes long. Now, how long is long? It's difficult to tell. What I would expect, what I would hope, let's put it that way, what I would hope is that once Commission receives a complaint and decides to, this something it needs to invite the company to come forward, within a year and a half, maybe, if we go more longer than 2 years, then what's the whole point of having a regulation? It's still not 10, but 2. Then the question is in these 2 years, is the Commission going to be late, or is the parties just stalling? So there is I have not seen any procedural guidance. How are you going to enforce DMA in practice? But I think if it takes anything more than 2 years, in my view, from starting a case against completing a case, taking into account, which is your first question I will come on to, the burden of proof, the weight, I think would be way too long for a regulation. What I do not know is how long due diligence regulation cases take. I have not followed that area too. I don't know how long it takes for Ofcom or for FCC in the US or for your regulator here on telecom to assess a case from a regulatory type perspective. On the burden of proof, the way I read Article 5 is what you very well described. Is I see Article 5 as these are conducts which are no-go. So if you do something like that, you are in breach of the regulation. Now, some of the conducts in Article 5, some part of the conducts in Article 5 are repeated in Article 6, data, for example, so then it depends on exactly what exactly are you doing. But when we go into Article 6, who has the burden of proof? That's a very good question. Who has the burden of proof? The Commission will need to decide that the regulation is breached. But so it has the burden of proof of proving that the regulation is breached. But this burden of proof is based on big tech putting forward, satisfying their burden of proof that my conduct is necessary and brings. It will not be bring efficiency. It's not about efficiencies. My conduct does not harm the way you think it does, and this is the evidence. So the Commission takes the evidence, still has to issue a decision of some type, which will say, I assess this evidence, I asked third parties, I took into account other reports, and I decide it's not a problem. So I think it's a shared burden of proof. I think there is more weight on the parties.
Okay.
Further questions?
First of all, I would like to thank everyone for the discussion and presentation. I'm still at the very first year of law school, so I don't know basically anything about regulation. But I would like to know how the Commission is concerned about drawing the line between propaganda and advertisement, for it may induce to the most diverse economic relations and concentrations and competitive problems. For you are always influenciating someone else, but when it passes from advertisement to propaganda, and it's harmful to society.
When you started your question with propaganda, I thought your question would be, how can the Commission be sure that it's not affected by a propaganda approach against or in favor of DMA or any other area? Not that there has been one, but I thought that's what you were asking, but it's not. So propaganda advertisement, that's not what DMA deals with, that's DSA. So Digital Services Act is going to deal with parts of propaganda and misleading advertisement. But there is also, at least in Europe, I assume the same here in many other countries, you have unfair consumer laws, they may be called slightly different in different jurisdictions, which deal with misleading advertising, for example.
Consumer protection.
Yeah.
So I think that's a more consumer protection aspect, and that's DSA, that is not DMA. It's still part of DSA, it will still be enforced by the Commission, but in Europe you also have all the, most I guess countries also have the ability to go against this type of conduct. In some countries the competition authority which does it, like in the UK, and maybe in Spain, I'm not sure. In some others that you can either go to court directly, or there will be other authorities, there will be consumer agency who will be dealing with this type of aspects. And there's no propaganda in Europe, just to state that.
Further questions?
Can I ask a question? I thought it was very interesting, the table that you have assembled, like comparing the conduct and the investigations. And I think it shows like the urgency that like the Commission identified the problem and they want to deal with this. And my question, I don't know if it's working.
Yes.
And my question is that, to me, it also shows that there is some sort of like overlap between competition and the DMA system. And especially because many of the investigations that you've shown have not reached final decisions. So, and especially when it comes to the Article 5 context that you've shown that has like little room to present defenses, actually it has no room to present defenses. These types of like contradictions between the decision that, I don't know, if the court reverts some of these decisions, this can be very interesting to see how it's dealt like, between those two systems, and how do you think this overlap can be solved?
That's an excellent, that's a point which I hadn't thought of. Let me start with your first point on the comparison between the cases and the areas. You are right, some of these cases are not decided yet, most of these cases are not decided yet, but if we look at past Commission's practice, if the Commission reaches a stage to initiate an investigation and advance an investigation, it is very unlikely that the Commission will not decide against the company. The Commission launches, they will come public about an investigation, they will actually proceed to the stages that they are now. If they feel confident, they will issue a decision against the companies. So I don't think we will see Commission dropping any of these cases there. But if they go to court and the court shoots it down, then that's an interesting question. Because if the court shoots it down based on substantive issues, not something that the General Court and ECJ and Court of Justice have done many times, but they have actually changed their approach on some substantive aspects, then what does that tell for the same conduct as part of DMA? I think what I would say if I were in the Commission and I had to come up with a safe-facing argument is that this case fell on substantive grounds within a specific factual context. But a different factual context, it would not have fallen as a case. So I can still consider DMA valid, that particular clause valid of DMA, because I will apply it in a different way in the next factual context, taking into account what the court said. But it will be surprising to see if the court starts rejecting a number of these cases of DMA, for example, sorry, let me go back. If the court starts rejecting these cases which are outstanding now, this will be a blow to the DMA mechanism in my view. And I also want to see what will happen if the court starts rejecting, annulling DMA decisions. What will happen then? Not very likely scenario to see, by the way, just because of how European General Court and ECJ have been operating until now. But you never know.
Yeah. Can I just have follow? Go ahead. Go ahead.
No, I was just thinking that because you started saying that probably the DG Comp will be the one applying the DMA, and if you think that it's possible that the DMA should be in this scenario that the court is upholding some of these decisions, that the DMA should be used as a shortcut instead of using the competition law system.
I think the point that the purpose of DMA is to be a shortcut to conducts which can have a significant impact and are very dynamic as conduct in this type of markets. I think DMA is aimed to be a shortcut in these markets.
But then, just to follow up on that, from its strategic point of view, if that's the case, then the Commission should stop opening new cases